You're listening to the Max Planck Lawcast, which showcases the academic research currently being conducted across the Max Planck Law Network. I'm your host, Christopher Murphy, and together we'll be talking to some of the more than 400 researchers who are pushing the frontiers of legal knowledge in Germany and abroad. When it comes to new and exciting legal research, the Lawcast has you covered. Well, thank you very much for joining us on the Max Planck Lawcast. Today's episode is all about the law in action. While the preconception might be that legal researchers spend their days tucked away in musty old libraries, my guest today will tell us about the exciting and highly practical work that his institute plays in a growing number of court proceedings. The reason for this is in a globalized world, German courts are increasingly being asked to apply foreign laws in local proceedings. As German judges don't always have the required expertise, they're turning to legal experts for the assistance that they need. To tell us more about this, I'm happy to be joined today by Jan Peter Schmidt. Jan works at the Max Planck Institute for Comparative and International Private Law in Hamburg, where he and his colleagues assist German courts by delving into all matters of international private law. Jan, welcome to the program.
Hi, Chris. It's great to be here. Thanks for having me.
Yeah, wonderful. Well, let's get straight to it then. Tell us exactly, I gave a little bit of an intro there, but what is it that you and your colleagues do?
Well, the German system of procedural law requires judges to be able to understand and apply not only German law, but also foreign law in a case where foreign law is applicable. So obviously, judges usually lack the knowledge of the foreign law they are expected to apply. And so they ask for expert opinions, or they have the possibility to do so. And we provide these expert opinions. Maybe I should clarify that we do this not for public law or criminal law, but exclusively in the area of private law. So let's say contract law, family law, company law, the law of succession, etc.
Okay, right. And so you say that this is in the German system. Is this something unique to the German system where the judges feel that they're a little out of their depth in laws that they need to apply? Or does this happen in other legal systems as well?
Yeah, German law is not unique in that regard. There are many countries who do the same thing, but there are also other ways to do it, other approaches. For example, in the common law world, the traditional rule is that foreign law is regarded as fact, not as law.
Okay.
So the judge then can ask the parties or the party who relies on foreign law to prove that law. And then it's the party who has to bring her own expert.
Ah, okay. So that's then in the prerogative or the responsibility of the party, who's, right. Whereas in the German system, it's more that the judge says, I want an impartial view of the law.
Yes. German law treats foreign law as if it was domestic law. So like the German judge has to know domestic law, he's also expected to know foreign law. And if he doesn't know it, he has to or she has to go and figure it out. Of course, the judge can try to do it on her own, but often that will be difficult. So then the judge turns to some expert.
Okay, right. I see. Okay. Well, let's say, okay, so the judge feels that they need information here on a law in Brazil or Australia, Paraguay, anywhere really. What happens next? They reach out to your institute for assistance. Tell us how the ball then gets rolling.
Yeah, so they reach out to us with a specific question usually, or maybe first with a general question, and ask whether we would be ready or available for this kind of opinion. So we receive many of such requests, basically on a daily basis.
And from across Germany? From
across Germany, sometimes even from neighboring countries such as Austria, Switzerland, but the great majority is from German courts, yes.
Mm-hmm. Okay. And so they write out to you and say, hey, we've got this job. We need an expert opinion here. And then you get lots and lots of requests every day. Yeah. How do you then decide whether we're going to accept it or not?
Yeah, so we look at the case, we look at the country that's involved, we look at the subject matter, the specific question. And when we need to see whether we are actually able to do this, we provide expertise for many countries, but not for every country all over the world. Our possibilities are also limited. Sometimes also the colleagues are already overloaded, maybe with other cases. So it also depends on the complexity of the case. So in short, there are many factors which determine whether we accept the question or whether we have to reject it and maybe help the court to find some other expert.
I see, because that's right. I mean, this is not the sole thing you're doing at your institute, right? I mean, you're also researching a whole lot of other private law matters.
Exactly. So our main task is to do foundational research in the areas of private comparative law, private international law. So the service which we are offering is just one aspect of the work we do. And that's why it's somehow subordinated to our other work.
Okay. It's probably a silly question because it definitely does vary from case to case, but could you give us maybe a rough idea of how long it then takes to write an expert opinion?
Well, that very much depends on the case. There can be dramatic differences. Some questions can be answered in 30 minutes or in 1 hour, and others will take several weeks.
Oh, okay. So that's something where you would take on and then maybe you'd say, oh, I know the answer to this one here. Quickly send a mail back.
Yes, exactly.
Okay. Right. I see. And others require more research from your side as well.
Yes.
Okay. Does this slow down the court system, having this requirement to contact experts and get expert opinions?
Of course. It slows down the procedure significantly, and it also increases costs. Maybe we will talk later about.
Yeah, I wanted to come back to the costs a little later on.
Yeah, I mean, it's somehow inevitable because once the judge is unable to figure out the solution under foreign law by him or herself, then the expert opinion is indispensable, and usually they take time. So that's something that has to be accepted. Unfortunately, there's no real alternative. Of course, we try to be as efficient, as quick as possible.
Okay.
But of course, we also want to provide correct answers. So we take our research into these matters very seriously. And as I said, we have many other obligations as well, of course, and many other tasks. So it can take its time. But as I said, we try to minimize that time.
Okay. So if you've written an opinion and given it up either, I guess, via email, but probably the vast majority are not always so quick, and you put it down on paper, send it in, do you ever then get called into court? You always see these kind of experts on legal documentaries and legal movies getting called in and being cross-examined and the like. Is that also something that happens to, or can happen to you?
It happens. It doesn't happen regularly, but occasionally it does, that we get called. And this gives attorneys and judges to clarify matters, to ask further questions. Also, of course, sometimes the reason is that one of the parties is not happy with the result of the opinion.
I could imagine.
We are, of course, impartial, but of course, the answer benefits either one side or the other. And then the party who's not happy might try to undermine our opinion in its content, or maybe also the authority of the person who has written it, like questioning whether that person has really the sufficient expertise, let's say, on Brazilian law or whatever. But I have to say they rarely succeed.
Can they also then bring their own?
They can, of course. Yeah,
they can. Okay, they also have the right to do that? Okay.
That sometimes happens as well. And then the judge might ask us to look at this additional private opinion, so to speak, and maybe comment on it and say whether we will stick to what we've written before or whether we see any reason to change our view. That happens as well, yes.
Okay. So it's not just book work, it can also be court work. Yeah, very good. Well, don't go away. Jan and I will be back after this short break to talk more about what he's doing there up in Hamburg.
Welcome to Max Planck Law, one of the world's largest networks for legal research based in Germany. Our world-class institutes invite applications for fully funded PhD and postdoc opportunities in almost any area of law. Join a thriving community of over 400 researchers in an international and interdisciplinary environment. Experience the high quality of life that Germany offers while collaborating with colleagues across institutes, working and writing in English. We provide you with unique specialist libraries, excellent workspaces, and support in developing your research and your academic career. Apply today. For more information, visit law.mpg.de.
Welcome back to the Lawcast. So I've talked with Jan before the break about what his colleagues actually do when they get a request from a court. You know, money makes the world go round. So my next question is, do you actually get paid for the services you're offering, or is this all done on a pro bono basis?
Yeah, important question, of course. It's not done pro bono. We charge an hourly fee, which at the moment is 155 euros, which corresponds to some general rule on the fees of expert witnesses in German courts. And so this is then part of the overall cost of the procedure. And I have to say, sometimes these costs are higher actually than the value that parties fight over. But yeah,
the cost of getting an opinion, basically, they could be fighting about something for several, let's say 5,000 euros. But if it's a really unusual area that you're researching on, you can go over that. Okay.
Yeah, sometimes parties fight over 300 euros. You wouldn't believe it.
Oh,
yeah, sometimes.
Wow, okay.
We do.
And you get called
and then,
in
of course, we might even point out that our opinion will cost maybe triple the value of the actual litigation value. But if the court and the parties want to go ahead, then we do it. Yeah.
Okay. And so it's the parties who are paying the costs then?
Exactly. Ultimately, it's the party. Usually the claimant has to make an advance payment to court. But then ultimately, it depends on who wins or loses the litigation. And then that party has also to bear the cost of the expert opinion. Yeah. And then we get paid by the court. So we don't have to deal with the parties directly. But then the court charges the party that lost.
Right. That's definitely handy. Oh, okay, right. And that goes into a coffee jar in the office then? Or what do you do with the 155 euros per hour?
That goes to the institute. Yeah. Unfortunately, it doesn't go into the pocket of the...
Okay. for more research books so you can broaden your horizons.
Yeah, exactly.
Okay. I'm going to say, I've worked in a law firm before, and 155 euros for such a bespoke service doesn't exactly sound like a king's ransom. Do you sometimes think, is it worth it?
Of course, you're right. Law firm would charge much more, especially in view of the fact that it's very specialized knowledge, which we have. But first, there are some legal restrictions. So unless it's a really exceptional case, the court wouldn't be allowed to give us more than that. So there's like a legal limit. But then the more important reason is that we are not really in it for the money. It's more like a service we do for society at large and for German courts in particular, who simply need someone to help them. We have our library, we have our resources, we have, of course, researchers who have expertise with regard to certain countries or even regions in the world who have the necessary language. So we are in a very good position to do that kind of work. And so we also feel kind of obliged to do it within the means that are possible for us, so that it doesn't interfere with our general research. And also, I should say that our general research also benefits from this practical work. We often receive interesting insights or impulses from these practical cases. And also it is actually quite rewarding for a comparative lawyer or a private international lawyer to be able to put your knowledge to direct practical use, to see that a case is actually then decided based on the opinion. And so it is an interesting topic in itself. Yeah.
Yeah. Oh, okay. I can definitely understand that. I mean, it sounds noble what you do, but as you say, there's also benefits for yourselves as well. And getting you out of the library, as we said in the introduction. You mentioned at the start briefly there that you get a lot of requests. I'm guessing then that's more requests than you can handle.
Much more, exactly. Yeah, we receive far more that we can handle.
As a ballpark
very
figure?
Visible that,
are we talking like a sort of ballpark figure? Are we talking about you get 100?
Maybe we get about 200 requests a year.
Okay.
And maybe we can do like 40, 50 of them. So maybe a fourth or even less.
Yes.
So it is obvious that the need for these opinions is growing in a globalized world, that German courts have more and more cases with an international element where they are required to apply foreign law. And there are only so many experts who can give these opinions. Of course, we are not the only ones in Germany who do this, but we are one of the primary institutions. And so it's a bit of a problem. Sometimes courts struggle to find an expert who can help them. Mm-hmm. The general problem is a bit that the legislature creates many instances in which courts or other public authorities are obliged to apply foreign law, but we lack the general infrastructure that would be underlying that system that would actually provide the necessary information for that.
Okay, yeah. And in those cases where you don't have the ability, I guess you've got a good network of other colleagues who are involved in the field.
Exactly. We have a good network. We collect this kind of information. So whenever we have to reject query, as is very frequent, as I said, then we will try to at least help the court name some other possible colleague or institution.
Okay. I have a quick question there too. What makes an expert an expert? Do you have to go to court beforehand and the judge talks with you? Or how do you then prove that you are an expert or the person you've asked is an expert?
Yeah. There are no clear rules on this, actually. So basically, it can be any person that has sufficient knowledge of that foreign system so that you can give a reasonable, impartial answer, and of course, a correct answer, hopefully. So usually it's done by university professors or by senior research fellows. So, Of course, you would need some basic requirements, like the language requirements. So you would have to be able to understand the language of that system. You would have to be able to find the relevant sources. Let's say court cases especially. Preferably, you have worked on that jurisdiction before. Maybe you have even spent some time there, studied there, done other kind of research. Or maybe you are even from that jurisdiction. That is even better, of course. But that's rather the exception.
Okay. So when the judge writes to your institute and say, do you have someone?
It depends. Usually in our case, they write to us as an institution, and then we internally try to see, is there someone in our institute who could do it, who's like, in many instances, it's clear. For example, we have a colleague who's in charge of Chinese law. We have a colleague who's very knowledgeable in the law of the Islamic countries. We have someone for Latin America, Turkey, Poland. So we have also a kind of fixed system of distribution, so to speak. But we also have certain flexibility. So sometimes for example, recently we received some question regarding the law of Sri Lanka. And we actually don't have any clear expert on the law of Sri Lanka. But then we looked at the case and saw that it's not really very complicated, that we have some sources here. So then we decide on a case-by-case basis, like say, okay, we can do it in that case.
Okay, no, fair enough. So how many opinions did you provide then, maybe in the last year or two? And for how many different legal systems?
Depends a bit. For example, in 2021, we provided 57 opinions on 20 different legal systems. In 2022, it was a bit less. For several reasons. That can change, fluctuate a lot. It was 28 opinions on 15 different legal systems.
And what yourself, what's your country of expertise or countries of expertise?
For a number of years, I was in charge of our Latin American department. So during that time, I wrote many legal opinions on Brazilian law, Chilean law, Argentinian law, and so on. And nowadays, my main job is to coordinate these legal opinions and to read the opinions and also co-sign the opinions that my colleagues write to ensure a certain quality control.
Well, that gets me to a very good segue to my next question, which would be, do doubts ever arise? You've written an opinion, obviously you've given your best and you've co-signed it and said, yep, we're good. But is there ever the case that you're like, there's a lurking feeling in my mind that could be not 99.9%, but and in such instances, do you have to also pass that on to the judge?
Sure. That's actually quite common, that situation, that you read all the books you find in the library or that you find online, you read all the court cases you find wherever, but very often you don't find an answer that gives you 100% certainty. There might always be some reform which has been passed recently and which you don't know about, or there's some very recent court case, or there are also countries, jurisdictions, especially smaller ones, where generally there's just not a lot of information. Maybe not even all court cases are published. Or maybe this is a situation that the legal problem is maybe a problem that has never really been decided by any court. So then you are a bit in the dark. For a lawyer, of course, that's not an unusual situation, even for our own domestic
system.
That's true. We know that quite often the law is not really clear and you have all kinds of opinions and court decisions on that, controversial ones. So we have to live with that. The important thing is that we make this uncertainty transparent, that we tell the judge that here there's a certain gray area, so to speak, where we think probably that the solution would be this, but we can't be sure. And then it's up to the judge to decide what he does with that uncertainty.
Sure. Okay, I understand. When you actually get the cases, are they anonymized, or do you have all the facts there in front of you to look at and you know who the parties are, what they're arguing over, the amount involved?
Yeah, we get the whole file. Sometimes we don't ask for the file because we can answer the question like in an abstract fashion, but normally we ask for the file and then we get all the information.
Okay. Yeah. And so we've kind of worked all the way down now from you getting the first being questioned, asked whether you can offer an opinion, how long it takes to do, how much you get paid. What about the follow-up of a case? Do you ever, you're obviously interested to know what happens in the case or the outcome there. Are you given feedback on this?
Yeah, of course. We are very much interested. We explicitly ask the courts to send us their decisions afterwards. Usually they forget, so we send them a reminder. which sometimes is also ignored. But of course, in many cases, we do get then the feedback, or we can also try to, if it's a higher court, the decision usually will be published, so we could also find it ourselves. And yeah, we're very much interested in see whether they followed us or not, of course.
Yeah, certainly. Yeah, I guess that's right.
And of course, it's rewarding to see that they do, which they do in the great majority of cases.
Okay, well, that's very good to know. Speaking of cases, last but not least, maybe you could give myself and our listeners a few examples of cases that you and your institute have worked on in the last couple of years, maybe some more prominent examples.
Yeah, sure. Actually, it's hard to make a choice because there are so many interesting cases. Since they are all international cases, they are often already interesting for that reason.
Mm-hmm.
So I try to pick some that hopefully give you like a good idea. For example, one relatively recent example from the realm of contract law was related to the German stadium tour of a very famous Australian singer.
Oh, I might know.
I'm not sure if I'm allowed to say her name, but I'm sure you would know her.
Okay.
It seemed that the popularity of that singer had already been in decline, at least in Germany, since tickets sold actually quite poorly. And as a result, the German event organizer went bankrupt. And so then there was an insolvency trustee who put in charge of his estate. And then that insolvency trustee tried to reclaim a substantial advance payment, which the organizer had paid to the London-based management of that singer.
Mm-hmm.
So to get some money back. And then the question was what the organizer and the management had actually agreed upon in their contract, which was never really formally signed, but consisted of many, many email exchanges. So it was a question like, did they actually conclude a contract? What was the contract? How is that contract to be interpreted? All that was to be determined by English law, especially the question like who really had to bear the risk of the ticket selling poorly. We would try to give an answer to that under English contract law. Yeah.
Oh, okay, right. So the contract, or as I say, all the emails have been written in English, dealing with England, dealing with the management, which was London-based.
Yes.
Okay. Oh, wow. I'll have to dig into that and see who this once famous singer was. Another example, perhaps?
Yeah, I would also mention an example from the area of family law, which in general is a primary focus of our activities in that regard. So you can see from that there are more and more international families. And within that area, there's a relatively topical issue that concerns so-called marriages by proxy. So what I mean by that is that two people, usually foreigners who live in Germany, they want to get married, but they are unable to do that under German law, or at least to do it before the German authorities, because the German authorities require certain documents which they can't provide. So what they do then, or what many people have done, is that they mandate a third person to travel to a foreign country in order to conclude the marriage in their name.
Oh, that's possible without them being there?
Yes. Under German law, for example, it's clearly not possible.
No.
But under many foreign laws, it is. So then the question which arises before German authorities is whether this marriage is valid from the German perspective. Of course, these people then get some document, they go to the German authorities and say, look, I've married in the foreign country, we are now married. And the German authorities look at it and think, well, is it really the case? And this depends, among other things, on the question whether the place, the jurisdiction where they did that, where the marriage was formally concluded by a representative, whether that jurisdiction allows for such kind of marriage by proxy. And as I said, German law does not, but many jurisdictions do. For example, Mexico, there were many cases with Mexico, we also had a case dealing with Ghana. And so, yeah, this has been a very prominent topic.
Oh, I see. And then you have to look, is this marriage by proxy in Mexico legal?
Does Mexican law allow for this kind of marriage by proxy? There are other issues involved a bit. I simplified a bit, but that's really the core question. Yeah.
Okay. It sounds like a somewhat unromantic, but certainly a very cost-efficient way to get married.
It is, yeah. And the interesting thing is, of course, that these countries usually also allow that it's one representative who acts for both parties. So you don't even need to send two people, but one is sufficient.
Okay.
Who declares marriage with herself, so to speak.
Gosh. Okay. Yeah. Good. Wow. Very interesting. I had no idea about that. And maybe a final example before we have to unfortunately sign off.
Another example from the area of the law of succession, which is also an area that features very prominently in our activity. So there was a case in which a very wealthy German citizen from a also quite well-known family, he had traveled to Cyprus for a vacation. And unfortunately, on Cyprus, he was involved in a motorcycle accident. And as a consequence of that, he was hospitalized. So then in the hospital, he apparently felt that his end was near. He dictated a last will or his last will to one of the doctors. He signed it, and then there were also two witnesses signing the will. And then soon afterwards, he did, in fact, die. And then, of course, in Germany, the fight between his several children and spouses, he had also had married twice, and so he had children from different families. So they started to fight over the inheritance. And what the children from the first marriage, who received nothing under the will, what they argued was that, among other things, they argued that this will was formally invalid. And because under German law, such a will, the way he executed the will, this would indeed be invalid because German law has other requirements. But the question is, similar to the case of the marriage, does the law of Cyprus allow a will to be executed in that fashion as he did? Because if that was the case, then this would also be recognized, so to speak, by German law. So then the court wanted to know from us, like, how do you draw up a will under the law of Cyprus? What formalities do you have to comply with?
Oh, okay. Wow. Really interesting stuff. I think you're going to have to write a book at some point on this.
Yeah, actually,
all these different cases that you worked on over the years.
Actually, there is a kind of collection, not published by us, but by a colleague from university. But we also send part of our opinions who go into a kind of collection. So it's not a complete collection of legal opinions, but it's like a representative selection. Yeah.
Yeah, wonderful. Well, Jan, I'll let you get back to working on this collection of cases there. Thanks so much for coming onto the program today. I really enjoyed that. It was totally valuable insights into an area of the law that I didn't know much about, and the kind of role that you're playing that I guess for many is maybe unknown. So good on you. Keep up the good work.
Yeah, it was my pleasure. Thanks for having me.
Yeah, you're welcome. Say hello to all your colleagues in Hamburg for us. And exactly, I'll have you back on the program at some point in the future, I'm sure.
Yeah, that would be great. Thank you. Bye-bye.
Thanks for listening to the Lawcast. If you'd like more information about Max Planck Law, or if you'd like to get involved, please visit us at law.mpg.de.
Max Planck Law. Excellence in legal research.